On April 25, 2019, a Tesla Model S was driving itself down a road in Key Largo, Florida. Autopilot was engaged. The driver, George McGee, dropped his phone, looked down to grab it, and trusted the car to handle the rest. It didn't. The car blew through a stop sign and a flashing red light at over 60 miles an hour, slammed into a parked SUV, and ended the life of a 22-year-old woman named Benavides, standing nearby. Her boyfriend survived with severe injuries. 6 years later, a Miami jury reached a verdict that should change how you think about every self-driving feature being sold to you right now. Tesla was found 33% liable for her death. Not the driver, the car company. They were ordered to pay $243 million, and a judge upheld that ruling earlier this year, rejecting every argument Tesla's lawyers threw at it. Here's the question this raises, and the one most people never think about until it's too late. If a car can drive itself and it crashes, who actually goes to court for it? You? The manufacturer? Nobody. The honest answer is, it depends, and the law is currently scrambling to catch up to a technology that's already on millions of roads. Today, we're breaking down exactly how liability actually works when a self-driving system is involved, using real cases so you know exactly where you stand before you ever trust your life to one of these systems. Before we get into who's liable, you need to understand something most people get wrong, including a lot of news coverage. Not all self-driving is the same legal category. There are two fundamentally different systems being sold under similar marketing language, and they create completely different liability outcomes. The first is what Tesla calls Autopilot, or full self-driving, what's technically called a Level 2 driver assistance system. Despite the name, you are still legally the driver. The car can steer, brake, and accelerate on its own, but you are required to stay alert and ready to take over at any moment. Tesla's own website states it plainly. While using Autopilot, it's your responsibility to keep your hands on the wheel and maintain control of the car. The second category is what Waymo operates. True autonomous vehicles. No steering wheel control expected from anyone inside. No human driver in the legal sense at all. These are currently running as paid robotaxis in cities like Phoenix, Los Angeles, San Francisco, and Austin, and Waymo alone has logged over 170 million fully autonomous miles. This distinction is the entire ballgame for liability. When a Level 2 system like Autopilot is involved in a crash, courts have to untangle how much responsibility belongs to the human driver versus the company that built and marketed the system. When a fully autonomous vehicle like a Waymo crashes, there's no driver to blame at all, which means liability shifts almost entirely onto the company, the software, and the hardware itself. Let's look at how that's actually played out in real courtrooms. Back to the Benavides case, because the details matter. Tesla's entire legal defense rested on one argument. The driver was distracted, the driver looked away, the driver is at fault. Full stop. That's historically how these cases have gone. A human was driving, a human made a mistake, the human is liable. But the jury didn't buy it completely. Plaintiff's attorney Brett Schreiber argued that Tesla had effectively turned every Autopilot owner into part of, in his words, a beta test they never signed up for. The jury agreed enough to assign Tesla a full third of the blame, and because punitive damages aren't capped the same way as standard damages, that third of the blame translated into $200 million in punitive damages alone on top of the compensatory award. This wasn't a one-off. Tesla is currently facing what's been estimated at up to $14.5 billion in collective lawsuit exposure. In January 2026, Tesla was sued over a Model X crash that killed a family of 4. In March, a Cybertruck owner sued after her vehicle, running on full self-driving, allegedly attempted to drive off a Houston overpass. And here's the detail that should actually concern current Tesla owners specifically. In April 2026, Elon Musk publicly admitted that Tesla's older hardware, installed in roughly 4 million vehicles worldwide, is physically incapable of ever achieving the full self-driving capability. Which means, if you paid $15,000 for full self-driving on an older Tesla, you paid for something that, by Tesla's own admission, can never exist on your car. Not needs an update, actually incapable. A class action lawsuit is now arguing that Tesla sold a promise its own hardware could never keep. There's also a naming problem that's become a legal problem. In December 2025, a California judge ruled that Tesla's use of the word autopilot violated state consumer protection law and called the term full self-driving itself, quote, actually unambiguously false. Tesla discontinued the Autopilot name for new vehicles in the US and Canada the following month, but millions of existing cars still run the software under that name. The pattern across every one of these cases is the same. When the marketing promises more autonomy than the hardware can deliver, courts are increasingly willing to put real financial responsibility on the manufacturer, not just the distracted human behind the wheel. Now flip to the other category entirely. A Waymo, with no human driver, no steering wheel input from anyone inside. When one of these crashes, the entire legal framework that's existed for a century, find the at-fault driver, file against their insurance, simply doesn't apply. There's no driver to point to. In that vacuum, liability shifts toward what's called strict product liability. Under California law specifically, a company that makes a defective product can be held responsible for the harm it causes, without the injured party even needing to prove the company was careless. If Waymo's sensors misread a stop sign or its software fails to detect a pedestrian, the legal target becomes the company and the technology itself, not a person. And it's not theoretical. Los Angeles alone has recorded 268 reported Waymo incidents through late 2025. Company-wide, Waymo reported 154 crashes between 2023 and 2025. Most happened in broad daylight, in clear weather, meaning these weren't edge cases involving fog or black ice. They happened under exactly the conditions you'd expect a car to handle easily. One particularly telling incident: a Waymo vehicle sped through an active construction zone, terrifying the people inside. Waymo's response afterward was to offer the couple $120 in free rides. A car safety researcher from Carnegie Mellon, Philip Koopman, has spent over 2 decades studying autonomous vehicle safety, and he's pointed out something important. Waymo's own safety statistics, the ones used to argue these cars are safer than human drivers, are partly produced by researchers affiliated with Waymo itself. He's documented cases of Waymo vehicles driving into flooded roads and illegally passing stopped school buses 19 times in one Austin school district alone. None of this means autonomous vehicles are inherently more dangerous than human drivers. The honest data is genuinely mixed and still developing. But it does mean the legal system is now regularly being asked a question it's never had to answer at this scale. When a machine makes a decision at the expense of a human life, how do you put a price on that? And who actually pays it? Here's the practical breakdown based on where the law currently stands. If you're driving with a Level 2 system like Autopilot engaged and you crash, you are still legally the driver. You can absolutely still be found primarily at fault, exactly like the driver was in the Benavides case before the jury also assigned blame to Tesla. The manufacturer becomes a co-defendant, not a replacement defendant, and proving their share of the blame requires reconstructing exactly what the software did in the seconds before impact, using event data recorder logs, software version history, and the car's own internal sensor data. If you're a passenger in a fully autonomous vehicle like a Waymo, you typically aren't found liable at all unless you specifically interfered with the vehicle's systems. Responsibility shifts to the company, the fleet operator, the software maker, sometimes the hardware manufacturer for the sensors or cameras, and the case proceeds more like a product liability claim than a traditional car accident claim. And if you're a pedestrian or another driver hit by either kind of vehicle, your claim path depends entirely on whose negligence gets established: the human driver of the Level 2 car or the company behind the fully autonomous one. Either way, lawyers in this space all say the same thing: the company's data. Sensor logs, software version history, internal communications. Is the evidence that decides everything, and that data can disappear or get overwritten within days if it isn't formally preserved. George McGee, the driver in the Benavides case, was found 67% responsible. Tesla was found 33% responsible. That split between the human and the machine is where every one of these cases lands right now. And as these systems get more capable, that percentage is only going to keep shifting. So does self-driving mean you're not responsible anymore? Not even close. And the law is making that increasingly clear in real courtrooms, with real dollar figures attached. The technology got ahead of the legal system, and we're now watching that gap get litigated, case by case, multi-million-dollar verdict by multi-million-dollar verdict. If you found this useful, I covered the other side of this what your car already knows and sells about you in the previous video in this series. If this series is something you want to follow, subscribing is the best way to stay in the loop. The best thing people can do is to just be informed and acknowledge the risks they're taking. Thanks for watching.